Good morning and good evening. I just want to welcome everybody to the AMCHAM webinar with the U.S. Customs and Border Protection. Before we begin, I just want to thank KITA for partnering with us on this seminar. They are an amazing resource for every exporter from Korea, especially to the United States of America. I also want to thank Katrina Chang, the co-chair of the AMCHAM Trade and Customs Committee, for her strong leadership. I know we've done this before, and I'm very thankful for Katrina's leadership on these type of programs. But today we have some amazing guests with us. I'm so excited that we have John Leonard, Deputy Executive Assistant Commissioner at the Office of Trade. We had the pleasure of hosting John in Seoul a few years ago, and I'm so happy to have him back. John was really terrific, and I can tell you that the entire audience really appreciated his insights. And today, we're also very fortunate to have 8 of his colleagues at CBP joining us. What a fantastic panel today. I'm really excited about everybody joining. I'm also happy that we have Pete Acosta, the new CBP attaché at the U.S. Embassy here in Seoul. We look forward to supporting Pete in his new role, and I know that, like his predecessor, he can always count on AMCHAM. As you all know, trade enforcement is critical to the U.S.-Korea economic relationship. The world is faced with ongoing challenges in global supply chains, and it is now more important than ever to learn about how to navigate trade and customs regulation. And as I said before, we're very fortunate that we have a large panel of experts who will walk us through a wide array of issues. And given the time zone differences, I'm so appreciative of the panel's personal sacrifice to really teach all of us. I know that for John and many of his colleagues, it is way past dinner time for the panelists. And again, I just want to thank John and his colleagues for their outstanding and valuable service to the United States of America. And post-COVID, I can't wait to host John and his team here in person again. So without further delay, let me now hand it over to Katrina Chang, who will moderate the session today. And thank you, have a good morning, and have a great evening.
Thank you, James, for your kind introduction. Hello and welcome to today's webinar with U.S. Customs and Border Protection, CBP. Thank you for joining in today. My name is, again, Katrina Chang, Senior Advisor at Kim Chang and Co-Chair for the Trade and Customs Committee. We have a packed agenda, like James mentioned, impressive panel from CBP today. We'll start with our special guest speaker featuring John Leonard, who will be introducing incoming CBP attaché and moderating a panel of experts to discuss CBP trade enforcement. Then followed by my colleague, Soo-Young Min, who will share our experience in some CBP enforcement measures we have worked on, and conclude with Q&A sessions. As James mentioned, some of you may know John from August 2019 seminar. We are particularly grateful to him for accepting our invitation because I know of the many demands on his time. As the second highest ranking official for Office of Trade, Mr. Leonard oversees implementation and enforcement of U.S. trade policy, such as enforcing 500 U.S. trade laws, 14 trade agreements, directing 7 priority trade issues, PTIs, and collaborating with 49 other U.S. government agencies. Now, let's please welcome today's special guest, Deputy Executive Assistant Commissioner, John Leonard.
Thank you for that kind introduction, Katrina, and good morning to everybody in Seoul. We're very excited to be able to join you and go over our very wide portfolio of trade issues. I can tell you that in my over 32 years of customs experience, we've really never been busier than we have in the current times with trade. It's an extremely dynamic environment. There's a lot happening, both operationally and from a policy standpoint. And we're really happy tonight to have, as James Kim noted, 8 of our experts who not only direct programs, but supervise large staffs who run these critical trade programs. So I'd like to begin the evening by actually introducing our new incoming Customs and Border Protection attaché, who will be moving to Seoul from the US on or about November 21st of 2021. So roughly a little over a month, Pete Acosta will be joining our US Embassy and as our new Customs and Border Protection attaché. And he is replacing Mr. Ed Bayron, who was in country for a number of years, at least 5 or 6 years. So I just want to give Pete a moment just to introduce himself to you all at the chamber and to welcome him. So Pete, let me turn it to you.
Good morning, AMCHAM members. Certainly welcome the opportunity to meet you virtually. Certainly looking forward to my pending deployment to Seoul and to working with you and to connecting to you with CBP components. Wishing you the very best. Thank you so much. Thank you, Mr. Leonard.
Great, thanks so much, Pete, and we're excited to have you in Seoul. Okay, so we've got quite a packed agenda, and we're going to begin by discussing some CBP enforcement priorities in the trade remedy area. So you've been tracking, I'm sure, the major tariffs that the U.S. has been collecting over the past 3 to 4 years, including the China 301 duties, the steel and aluminum 232 duties, and we also have some narrow focus duty collection in the Section 201 area. Anti-dumping and countervailing duty has also been an ongoing issue, as you know, for many, many years. I'd like to introduce Branch Chief Ruth Waddy, who runs our Trade Remedies branch, and she will give a brief overview of what is happening in this very, very busy space. I will turn it to you, Ruth.
Thank you, Deputy Assistant Commissioner Leonard. Thank you for your warm introduction. So good morning, AMCHAM members. My name is Ruth Waddy, and I will be talking about the enforcement priorities that we have for the AD/CVD trade remedy programs and our policies that we issue. CBP works closely with partner government agencies to ensure that trade remedies are effectively implemented, and guidance is provided to the trade community through our cargo system messaging service. CBP monitors imports to ensure compliance with trade remedies, thereby ensuring appropriate duties are assessed and absolute quota levels are enforced and potential circumvention is detected and prevented. Under Section 232 of the Trade Expansion Act of 1962, certain circumstances allow the President to impose tariffs based on a recommendation from the U.S. Secretary of Commerce if an article is being imported into the United States in such quantities or under such circumstances as to threaten or impair the national security. On March 8, 2018, President Trump signed an order to impose tariffs on steel and aluminum articles under Section 232 of the Trade Expansion Act, effective March 23, 2018. And citing national security grounds that resulted in additional 25% duties for certain steel products and 10% on certain aluminum products. Effective February 8, 2020, imports of derivatives of iron and steel articles and imports of derivatives of aluminum articles were subject to an additional 25% and 10% rate of duties, respectively. Quota countries covered under Section 232 absolute quotas are Argentina, Brazil, and South Korea. And they are subject to a quarterly and annual rate of limitations of quantities. Commerce is managing a process for Section 232 tariff exclusions of steel and aluminum products in order to limit the tariff's potential negative domestic effects on U.S. businesses and consumers. As of February 7, 2021, Commerce received over 288,000 exclusion requests, over 260,000 for steel, and over 27,000 for aluminum. Of those requests, the agency granted over 170,000 exclusions and denied over 59,000, with over 44,000 exclusion requests rejected or withdrawn. The Bureau of Industry and Security of the United States Department of Commerce issues two kinds of exclusions: product exclusions, which are company, country, and quantity specific, and 123 generally approved exclusions, which are not company specific and has no quantity limitations. Pursuant to the President's memorandum on August 18, 2017, the United States Trade Representative initiated an investigation under Section 302B of the Trade Act to determine whether acts, policies, and practices of the government of China related to technology transfer, intellectual property, and innovation are unreasonable or discriminatory and burden or restrict U.S. commerce. As a result of the findings, USTR imposed additional tariffs ranging from 7.5% to 25%, covering 4 commodity lists with an annual trade value of approximately $34 billion for list 1, $16 billion for list 2, and $200 billion for list 3, and $300 billion for list 4A. USTR determines the rates of duty imposed pursuant to the Section 301 investigation via presidential proclamations and Federal Register notifications. USTR has granted over 22,000 exclusions to Section 301 duties that CBP has implemented. Almost all exclusions, except for those certain COVID related exclusions, expired in April of 2021. The COVID exclusion has been extended until November 14, 2021. On October 4, 2021, Ambassador Catherine Tai announced that the Office of the United States Trade Representative would start a targeted tariff exclusion process and the possible reinstatement of 549 exclusions that were previously extended. The public comment period will last for 50 days from October 12th through December 1st. As of October 13, 2021, Section 301 China duties has been assessed over 108 billion and Section 232 duties over 11 billion. In addition to the imposed duties on certain China imports, applicable 80 CVD duties are still required to be paid. The reinstatement exclusions will be retroactive to October 12th. USTR is seeking comments on the appropriate length for the reinstated exclusions. Thank you.
Thanks so much, Ruth.
I know it was a lot, but if you all have any questions, please let me know.
Yes, for any of our panelists, we can take Q&A at the end. You know, these trade remedies have actually doubled the amount of revenue that the U.S. Customs and Border Protection takes in each year. Prior to these remedies, we had been averaging about 40 billion USD a year in duties. Now with the 301s and 232s, we collect well over 80 billion USD per year. So it's a profound effect on our revenue collection. Let's quickly move on to the KORUS, right? This is a huge free trade agreement for the U.S. I know it's one that's of incredible importance to you all and to South Korea. So let's turn it to Jackie Sprungle to tell you the latest of what's happening with the KORUS free trade agreement. Jackie.
Thank you, sir. I'm glad to be able to join tonight and participate in this event. I would just like to highlight a few key points about the Korea FTA and in particular origin verifications. Verifications are issued by Customs and Border Protection generally to the importer of record in the US. And some of the, I think, best advice that we can give today is to say, be prepared for verification before it happens. So for those of you exporting to the US, be familiar with the rules of origin for the type of good that you are producing and exporting from Korea that will be imported into the US. Have a good conversation with your importer of record or the buyer for your goods. And these rules of origin can be found in the general notes of the harmonized tariff schedule of the United States. And information can also be found on cbp.gov and on the Office of the U.S. Trade Representative's website at ustr.gov. Knowing your supply chain, including the origin and costs of the raw materials that go into the goods that you're producing and exporting, is also key. This ensures that you're able to support that your goods do meet the requirements of the KORUS. Practice good record keeping for all steps in the transaction, from the placing and receiving of orders to the production and the packing of goods before export. And again, communicate with the US importer or the buyer. They may request some documentation if CBP reaches out to them to do a verification. Be ready to provide that supporting documentation, the information about the raw materials, the production steps, transportation, to the person that's importing the goods in the US, or it's also possible to supply those documents upon request to CBP directly. Updates can be found at cbp.gov. If you put into the search bar, trade agreements, Korea FTA, KORUS, there's a lot of information there on our website. You can also email the general CBP headquarters FTA mailbox, and the link for that is also there. So there are many resources available on our website. And I think really by doing these things, by being familiar with the rules of origin, tracking and documenting the production and the orders from beginning to end, and practicing good record keeping, by doing those things, you will be well prepared to respond to any origin verifications that CBP issues. And you will also avoid CBP post-importation duty bills on goods where CBP, if the documents cannot substantiate that the goods meet the rule of origin, CBP will issue additional duty bills, and it could affect your sales and your relationship with your US buyers. So please keep these things in mind if you're interested in shipping and exporting and importing under the Korea KORUS. Thank you.
Thanks, Jackie, for that really thorough, concise review of what's happening under the KORUS and how importers can protect themselves. So with that theme, let me turn it over to Amy Moore, our Field Director of Regulatory Audit and Agency Advisory Services in Atlanta, Georgia. Amy, tell us a little bit of what importers can expect when they are faced with a CBP audit, and any other information you want to convey about our audit program.
Thank you, Mr. Leonard. Appreciate that. And what I'll echo is follow up to the enforcement arm from the Office of Trade and for CBP in totality. CBP audits follow standards of auditing and accounting principles. The compliance reviews or audits are performed on a post-importation basis, which means after the goods have been released from customs. This process enables our ports of entry to process goods more quickly, allowing the legitimate flow of trade to occur quickly. By doing a post-importation review, we can process the enforcement action, looking at books and records for the direct and indirect involvement of the transaction. We can look at the business systems and the information that pertains to the entry of the goods after the goods have been released. This allows for freeing the resources at the ports of entry, all this at the same time making sure that our economy is protected from correct entry of goods at the for the process of declaring their accuracy. To define a risk-based enforcement measure, which is what was the title of my topic, you would have to understand that audits and investigations will first require that the importer understand the risk of importing goods into our country, which the previous two speakers and Mr. Leonard have alluded to, and we've been sharing a lot of information about what's published on this government website, cbp.gov, such as the trade remedies, and Ms. Sprungel just shared the KORUS information, which is available about how to comply with that. There's so many more information pieces about the risk of importing into the United States. Another area that we will be speaking to, I believe, was anti-dumping and countervailing duties, which the audit teams are addressing that through different avenues that was passed with the Trade Facilitation and Trade Enforcement Act, which is also information about that is found on cbp.gov. The audit teams support investigative research on these actions for looking into violations of anti-dumping and countervailing duties. I bring all this up to not make, the topic of this was risk-based enforcement measures. However, I wouldn't want the audience to fear an audit or an investigation as much as to plan ahead. Ms. Sprungel mentioned that, to be prepared. And a lot of that is easily summed up by saying that instead of fearing an audit or a review or a compliance evaluation or whatever you want to call it, it's a lot about knowing your product that you're planning to import or export from your country and import into the United States, knowing your supply chain, knowing your vendors, your partners, knowing how to map that supply chain, knowing the laws of the country, the United States, and what you're planning to import, being able to support your declaration to customs with documentary evidence. I think I mentioned at the beginning that auditors follow principles of accounting and auditing. For an auditor or an accountant, such as myself, the rule of business is documentary evidence. So many of you in the business world understand documentary evidence begins with a contract, purchase order. The beginning could be a purchase contract or a purchase agreement of some kind. An audit trail all the way to a payment record is what we're looking for. Documenting that trail and having those records, if asked by customs at the port of entry, you could be asked for evidence, or by an audit team. That's preparation. Having that audit trail in your books and records for every declaration you make to customs is key. That's preparation. You may be asking yourself, how long do I need to keep those records? The answer to that is generally 5 years from the date of entry. So I'm available for questions. I just wanted to wrap that up in summation, not to be fearful of an audit, but just be prepared. Thank you.
Thank you so much, Amy. Really good advice for any company that may be facing an audit or could face one in the future. It's just a matter of being well prepared. Okay, so let's kind of switch gears into the appeals process and penalties. So we do assess penalties. We're an enforcement agency. We are a law enforcement agency really at our core. And we do issue penalties against companies in the civil area. And we have due process though. So I'd actually like Sherry McCann and Sandra Barbosa to chat a little bit about how that process works and how you can avail yourself of these rights should you find yourself in this situation.
Thank you, Deputy Executive Assistant Commissioner Leonard, and good morning to our AMCHAM members. I'm going to start off speaking about ways that an importer may challenge a CBP decision, and then I will turn it to my colleague, Sandy Barbosa, to discuss the civil penalties and the process to petition those penalties. So if an importer disagrees with CBP's liquidation or finalization of an entry, they do have the right to file a protest. And the protest is that legal vehicle for importers and interested parties to contest CBP's decisions related to imported merchandise. So I'd like to go over a few basics regarding protest and then discuss quickly some best practices. Protest must be filed within 180 days of liquidation and may be filed by the importer, their broker, or attorney. Protests can be filed in two ways. First, by traditional paper submission at any CBP port of entry, or the second and more popular option is to file protest electronically in CBP's system of record, the automated commercial environment. So let's chat about a couple of best practices for filing protest. CBP has been inundated with protest in the last couple of years, going back to my colleague Ruth Waddy's presentation on trade remedies. Often the exclusions are not approved at the time of entry, so an importer has to file a protest to get those trade remedy duties back for an approved exclusion. So we like to share best practices to try to streamline the submission and the CBP processing of the protest. So logical grouping of entries by protest is very important. For example, again, going back to the trade remedies, with this extreme increase that we've seen in the recent years, it's important to group protest by a trade remedy exclusion, right? This will enable the CBP personnel processing the protest to vet that one issue and address it en masse across all of the affected entries on that protest. Another key thing to remember is to provide substantive information to support the protest. For example, if a protest is filed based on the harmonized tariff schedule classification, the protestant would want to provide information on the product specification, showing pictures, size, measurements, weight, the component makeup of the product, anything that gives CBP the exact information on the product, which will help us understand why the protestant is challenging the classification. Contact information is also very important to be filed with the protest. Up-to-date contact information of the person who can address the specifics in that protest. So that's the first challenge opportunity when the importer wants to challenge CBP's liquidation of the entry. If CBP denies the protest, so CBP can approve or deny the protest, and in situations where CBP denies a protest and the importer wants to further challenge that denial, they also have an option, which is to file a summons within the Court of International Trade. And the time frame to file a summons is, again, 180 days from CBP's notification of the protest denial. So those are two challenge options. And now I'd like to turn it over to Sandy Barbosa to talk about the civil penalties.
Thank you very much, Sherry. Good evening, everyone. How are you? I would like to briefly discuss some of the civil penalties that CBP can issue regarding trade violations. So Customs has the authority to assess penalties, and it's established by statute. So we could issue trade penalties for civil offenses for trade penalties. The assessed amount of these penalties vary based on the type of violation, what regulations or statutes were violated, and the domestic value of the merchandise. Civil offenses, some of the trade penalties that CBP issues involve IPR violations for intellectual property rights, commercial fraud penalties, record-keeping penalties, drawback penalties, and broker penalties. Those are just a few examples of the trade penalties that we can issue. And I'd like to briefly discuss two of the major ones that we see. Normally, a lot of the ones we see are for 1595 AB violations. That's in violation of 19 USC 1595 AB. It's a penalty for unlawful importation, for aiding or abetting unlawful importation. In summation, the regulation states that any person who directs or is involved in any way of unlawful activity shall be liable for a penalty equal to the value of the merchandise that is either imported or attempted to be imported. The second major violation that we see are 592 violations, which involve falsifying information in an attempt to defraud the government, trying to circumvent or not pay proper duties, taxes, and fees. For the 1595 AB penalties, mitigation is dependent on the aggravating or mitigating factors. For the first offense, it could be mitigated if mitigation is warranted, anywhere between 10 and 50% of the domestic value. Second offense is anywhere between 30% to 80% of the domestic value, and any subsequent violation thereafter could be mitigated anywhere between 50% to 80% of the domestic value. 592 violations are issued under a level of culpability. So depending on the culpability of either negligence, gross negligence, or fraud, a penalty could be assessed anywhere between 0.5 to 8 times the loss of duty. You have the right, the importer of record has a right to petition a claim. So if a claim is to be petitioned, if you don't agree with the violation, you have to submit a penalty. I'm sorry, I stand corrected. You have to issue a petition within 60 days of the date of on the bottom of your notice. So your penalty notice is usually mailed to you. Sometimes it's emailed, and you have 60 days within the date of the bottom of the notice to file a petition with your local FP&F office. As far as criminal violations, I can't speak too much to that. CDP does not bring criminal charges against importers of record. Criminal offenses are handled by Homeland Security Investigations, known as HSI. HSI may investigate smuggling or other importation violations issued under criminal US code. But you should be made aware that criminal cases can run congruent to the issuance of a trade penalty. So while customs can issue a trade penalty to an importer of record, in conjunction, HSI can also issue criminal charges or be running a criminal investigation. And finally, I just wanted to let everyone know that with the option to submit a petition, you also have the option to submit an offer in compromise at any point in the process. But an offer in compromise needs to be a written form letter explaining why you believe customs should accept your offer in compromise if you don't like the assessed amount or the mitigated amount. And in conjunction to the letter and your reasoning with your justification, you have to submit tender. You have to tender the amount that you wish for us to settle the claim for. So if you submit a letter of an offer in compromise without the payment, without tendering the funds, it's not a complete offer in compromise. I will be available for any questions if you have any questions or concerns about anything that was discussed. Thank you.
Awesome. Thanks so much, Sandy and Sherry. Really good advice on an area that's very concerning to any importer should they get a penalty from CBP or wish to submit a protest. Okay, let's turn over to our Customs Trade Partnership Against Terrorism. This is our Trusted Trader program that went into place soon after 9/11. Our director, Manny Garza, will speak about that and also very briefly touch on export controls. Manny, I will turn the floor to you.
Good morning, everybody, and glad to be a part of this conversation. So as the director of the CTPAT program, I'm responsible for over 11,000 partners in our program. I've got 6 field offices and a team of about 180 employees. And it's been a tough year. It's been a tough 18 months, I should say. for the CTPAT program for the world. You know, but we had to figure out what were we going to do. You know, during a normal year for the CTPAT program, you know, with over 11,000 members, we have to do roughly, you know, 2,500, you know, 2,500 validations a year. Last year I did 164 in-person validations. That was not a lot of validations. So I challenged my team and I said, look, we're doing Zoom meetings, we're doing Teams and every other platform out there, like all of you folks on the line today. And I said, let's figure out a way to validate our partners. Maybe not everybody, but there's got to be a way to do this. And so we began developing our standard operating procedures for virtual validations. And I should say that, you know, while I did have the team start, you know, moving faster on this, it was actually something we were already preparing to do. I saw the attendee list, you know, that had registered, and a lot of US companies that are CTPAT members, and several that are CTPAT Tier 3 members. And so we were actually looking at trying to do virtual validations as a benefit for Tier 3 members. You know, the COVID pandemic threw a wrench in our plan and said, no, we're going to have to do it for almost everybody. But I'm happy to say that because of the virtual validations, we've done about 1,800 of those now. That's really been beneficial for the program. It's definitely making we're making sure that companies are still meeting the requirements. It's not in person, but again, like I mentioned, we're doing this based on risk, and we're doing this for our best partners. A lot of companies, you know, that we're not doing this for are brand new companies that we've never visited, new applicants, or companies that have been applicants and we just haven't been able to visit. But let's not forget the other part of this and what CTPAT and Korea Customs AEO program, you know, in 2010, we signed a mutual recognition. And I think in 2010, I participated in several observations of the validations in Korea with customs. And I haven't been back since, sad to say, but definitely need to make it back and continue to work with my partners there with Korea Customs. But what's the point of having mutual recognition? In case you're not already aware of it, what CTPAT does is, if you are if you're a member of Korea Customs AEO program, we're given your information about your company and we input it into the CVP system. And regardless of who's importing the goods in the United States, could be your sister company that's in CTPAT, that's great. Could be somebody who's not in CTPAT. But we do provide benefits for our Korea Customs AEO members that are shipping goods to the US. And those benefits result in fewer examinations of your exports into the US, your imports here in the US. And if you are set up for examination, we're reducing the we're giving you front of the line privileges as well, which means that, you know, when they're all lined up, all the containers are lined up for inspection, they'll work on the CTPAT ones first, including our MRA partner ones. So I think that's something that's really good, and what mutual recognition has allowed us to do in terms of we accept validations from each other. So when Korea Custom does validations And if CTPAT needed to go do a site visit in Korea, we would look to see if it's been validated already, and if so, we don't have to travel there. So worldwide, we've in the last 18 months, we've accepted 550 virtual we've accepted 550 validations based on our mutual recognition with our 14 MRA partners. So lots of work going on, lots of great benefits, and you just heard from Sherry and Sandra talk about penalties and how to help mitigate. And I can tell you that we are working, CTPAT is working on a plan for our penalty mitigation as being a CTPAT member. We're also looking at the opportunity, we have that in place today. Let me rephrase that. That is in place today. However, we are working on a plan to provide benefits for our for the exporters or for our foreign partners that are in an MRA AEO program. So if there was a reason for a penalty, there could be an opportunity for mitigation, something we're working on down the road. And then just the last couple of things I'll say related to CTPAT is that we are continuously working with Korea Customs on our updating our side-by-side comparison of our programs. We've CTPAT updated the criteria in 2020. And so we've asked all of our MRA partners to align their criteria with the newest criteria that CTPAT has. So that work continues. We just completed a joint review of our manufacturer ID numbers, which is how we provide benefits in our targeting system. And I will let everybody know that unfortunately I didn't provide it in advance, but I do have a guide basically that I want to share with you all, because I'll tell you that MIDs are a really, really tough thing for us. We call them MIDs, manufacturer ID numbers. They're always incorrect, and if we don't have the correct one on file, there's no benefits being provided. So that's what I have on my CTPAT program. And just to talk briefly on exports, I did get some bullets from my colleague, Mr. Jim Swanson, who manages our export division. And he just wanted me to make sure everybody was aware that CBP is aware of the role that we have as the point of the spear for export enforcement. We play a role as the border agency of the enforcement and sanctions on behalf of other agencies, such as the BIS at Commerce, the Department of State, and OFAC with Treasury. They're the ones that establish U.S. exporting license requirements and sanctions as well. We manage a single window process for exports to link licenses and permits with declarations so that we can verify that information. And we're always looking for ways to improve our enforcement posture, including with the export realm, while at the same time trying to facilitate legitimate trade. So that's what I've got here on exports. I know you guys were interested. Mr. Leonard, I'll turn it back to you, and thank you everybody again for having us.
Thank you so much, Manny. So in the interest of time, we're going to do a kind of a truncated session on the challenges we've been facing in the COVID-19 environment with Sherry McCann. And I'll ask Sherry to then quickly turn it over to Cindy Pre, who's going to be talking about really one of our busiest areas lately, which is forced labor. And then we want to make sure to allow time for our colleagues at Kim Chang for their presentation as well. So Sherry, let me quickly turn it over to you.
Thank you, sir. So I wanted to just chat quickly about, the supply chain disruptions. It's the current world that we live in today. And Director Garza just provided great input on, CTPAT and how we've adapted that in this COVID environment. And continuing along that line, from an overarching view, we in CBP certainly recognize the COVID-19 pandemic, the impacts that it's had, and the disruptions caused across the supply chain. We have ongoing ramifications with these disruptions today, impacts to trade overall, imports and exports. And we understand, the ripple effects that go throughout industry as well as infrastructure, and we're seeing multiple waves. So, where does CBP, where does US Customs and Border Protection, fit into this, and how do we address this situation? So our CBP Office of Field Operations, represented in today's session by Director Garza, has overarching and critical responsibility for the clearance of cargo, right? So from the CBP end, we are working diligently with the trade community, with our government partners, with port operators to ensure that merchandise is cleared as efficiently as possible. CBP has remained fully operational since the start of the pandemic. We are committed to working with government and industry partners to do our part to keep the supply chain moving. CBP is available to conduct exams as necessary, and we're working to ensure that we're not delaying the release of cargo unless absolutely necessary. So again, CBP is doing everything we can and looking for all new efficiencies to keep freight moving within our area of responsibility. And our Office of Field Operations is doing an amazing job at that, clearing efficiently as fast as we can, and working with our partners to keep that. So we encourage input here. We're really trying to be the good government model partner to do our part to keep this going. So with that, I'm turning that over now to Cynthia for the discussion on forced labor.
Thank you so much, and I really appreciate the opportunity to talk to you all about forced labor today, which obviously is an important global issue. So according to the International Labor Organization, as you may be aware, about 25 million people worldwide are currently being subjected to forced labor conditions. About 16 million of that number are being exploited in private sector industries such as domestic work, construction, and agriculture. The US is committed to preventing goods made with forced labor from entering the country, and federal law prohibits the importation of merchandise that's mined, produced, or manufactured, wholly or in part, in any foreign country by convict labor, forced labor, or indentured labor. If you're planning on importing goods to the US, it makes sense to take proactive steps to understand and comply with US laws against forced labor. I'd like to just give you a brief overview of how CBP enforces forced labor laws. When CBP has information that reasonably indicates that goods being made with forced labor are likely to be imported, CBP will issue something called a withhold release order, or WRO. CBP will then detain goods subject to that WRO at the border and issue a detention notice to the importer of record. Importers of goods detained under that WRO then have 3 months to submit proof to CBP that the goods have not been made with forced labor or re-export the goods. If the importer fails to take either of these actions, or the information submitted is insufficient for CBP to determine whether the goods were not made with forced labor, CBP will exclude the goods from the US. Now, if CBP has conclusive evidence that indicates that merchandise being imported is produced with forced labor, CBP will issue what's called a forced labor finding. And once a finding is issued, CBP can then seize and forfeit the merchandise. CBP also can issue penalties against importers who import goods made with forced labor. As one recent example, in 2020, CBP collected a penalty against an importer of approximately almost $600,000 based on importation of stevia from China. During this fiscal year, which ran from October 1st, 2020 to just recently September 30th, 2021, we actually issued 7 WROs and 2 findings. And right now there are 50 WROs currently active that CBP is enforcing. and those would be against a specific foreign entity or a specific geographic region. What might be of interest, notably this year, CBP issued 3 WROs that addressed human rights abuses in the Xinjiang region of China. And those were cotton produced by the Xinjiang Production and Construction Corps, cotton tomatoes produced in the Xinjiang Uyghur Autonomous Region, and silica-based products produced by Hoshin Silicon Industry. So it's important for importers to remember that downstream products made in third countries that incorporate some of these inputs are also subject to these WROs. Some examples of covered products include apparel made with Xinjiang cotton, perhaps tomato sauce made with Xinjiang tomatoes, or circuits or solar panels made with silica-based Hoshin products. This year, CBP detained almost 1,500 shipments worth of about $486 million under all of our active WROs. So rather than risk detention and exclusion and possibly seizure of goods, we do recommend that you ensure that your supply chains are clean of forced labor at any point. We do recommend that you become familiar with the reasonable care standard that CBP expects from importers importing goods into the United States. Those standards can be found on our website. Our reasonable care publication includes a whole section on forced labor and advice on measures that you can take to ensure that you are complying with US law. We also recommend that importers be familiar with the International Labor Organization's 11 indicators of forced labor, as well as existing our WROs and findings on the CBP website. So with that, I'm happy to take any questions.
Excellent. Thank you so much, Cindy, for that very comprehensive review of a very topical area. At this point, let me turn it back over to Katrina for the presentation from Kim and Chang.
Thank you, Mr. Leonard. Thank you for all that excellent presentation. It's great to see my former colleagues today, so many of my colleagues today. Now let's please welcome our next presenter, my current colleague at Kim Chang, Soo-Young Min. She will share her experience in dealing with some enforcement measures that Mr. Leonard and CBP panelists have addressed today.
Thank you, Katrina, and thank you to AMCHAM's Customs and Trade Committee for this wonderful opportunity to hear directly from the panel of experts from CBP. So after hearing some of the presentations, we thought it would be great for us to present to you some of the cases that we've seen that have direct or indirect involvement of CBP, and let you know what are some of the processes that you might want to consider to both reactively as well as proactively manage some of the compliance risks that may arise. So just to look at some of the initial encounters that you may see, a lot of you who are attending this webinar may already have come across some of these cases. So we wanted to present to you some of the cases that come up during your transactional structures, including what you most commonly encounter in trade remedy cases, anti-dumping CVD investigations, as well as some of the audit cases, and what are some of the ways that you might encounter these CBP involvement during these cases. So for example, during an anti-dumping case, which might be initiated through a domestic industry filing a petition with the US DOC ITC, you have the proceedings that are relevant for the AD investigation. And while the investigation is pending, you are obviously going through a lot of your documentations relevant to import into the US, whereby you may discover that there are some issues with the entries that were submitted during the import process. And this will arise sometime during the anti-dumping investigation process. So there are processes available for you to consider on how to resolve this issue while the AD case is pending. And those are some tools that you have related to CBP's processes that you should understand that these options are available to you. For example, prior disclosure of certain errors that you found during the review of the documents while you were defending on the investigational side. So those are some proactive measures you can take while you're reacting to an actual pending case. So that's one example. The other cases are, we've come across a lot of survey questions that are issued by CBP, and companies have an obligation to respond to what may be referred to as a pre-audit survey. So these are survey questionnaires that are issued to the companies that are designed to allow CBP to find out about your import processes or products that are coming in, et cetera. And these are questions that have some time limitations in order for you to respond fully. But you have to ensure that these pre-audit questionnaires are responded in full and accurately. And this will require you to get some input from your affiliates, as well as your suppliers, as well as making sure that you can look through the records to find the accurate information that dates back to however many years that you need to look at in order to respond to some of these pre-audit survey questions. Now, the importance of these audit questionnaires is that they're designed to give you an opportunity to present your responses to the CBP's questions before it actually turns into a full-blown audit, for example. So sometimes we get inquiries about how seriously do we have to take these pre-audit survey questionnaires and how fully must we respond to them. And I think one of the factors that you really want to consider is that once it becomes a full-blown investigation or an audit, you're in a very different position of trying to resolve whatever issues that may come up during the audit process. So you want to be able to take advantage of these tools available to proactively manage some of the risks that come from trade compliance related matters. Now, for lack of time, I want to go through comparison of proactive measures versus reactive measures and go to some key messages that we think you should take from this presentation. So what I mean by reactive is you have a case that's open and you get notified of certain actions being taken from regulatory agencies such as CBP regarding compliance. So you get a notice and you have to ensure that you timely answer and ensure that you have a team available to start collecting the information, as well as strategizing about what you need to do in order to effectively respond to an open case. So this could include an audit, compliance nature. This could include an AD investigation. And a lot of companies know how to respond to an AD investigation, but you may not have all the tools in place internally to respond effectively and efficiently to an audit, for example. Now, a flip side to a reactive measure designed to react to certain enforcement measures taken by CBP, you have a couple of tools available in a proactive manner. So, for example, I mentioned that you may have an error discovered during an AD investigation review or a mock audit that you have done. There are tools available such as prior disclosure of certain errors. So this is a measure designed to give you an opportunity to correct certain errors that you find in your importation export processes, for example. But these measures can be taken only before an actual investigation is opened on the side of CBP. So this requires you to do, for example, a mock audit of your company's compliance system to see if you could get some records from your customs broker to ensure that all the compliance measures are being followed. And any AD measures that you have in place, you need to make sure you have a compliance system in place that allows you to ensure correct information is conveyed to the customs broker, and therefore customs broker, for example, will file the correct information during the import processes. So in addition to such tools as prior disclosure rules, you also have opportunities to request certain rulings from the CBP. So for example, you have questions about certain origin verification issues. There are ways to open a communication channel with CBP to proactively manage issues before they become an issue. So just want to jump to a key takeaway and some of the proactive measurements that we would like you to have in place. You want to make sure that you have a compliance check system in place that requires regular training of different departments within your company, not just trade compliance department. Because the trade compliance departments that a lot of companies have, or their legal departments, don't usually become aware of an issue until it becomes an issue through an audit, for example. So you need to have some sort of training or a system in place to ensure that a lot of your employees know sufficient information to raise an issue with trade compliance or legal departments in your company. We always encourage mock audits if you believe certain documents may raise red flags. During AD investigations, prior disclosure is an option. And we encourage our clients to, for example, do an active review of supply chain. Now, there are some limitations imposed by the fact that there may be third-party affiliates or third-party avail in your supply chain that you cannot really dictate how they should keep records, for example. But one of the panelists mentioned some of the penalties involved with record keeping. But we're not only concerned about the penalties from the record keeping per se, but the fact that you may be denied a preferential tariff treatment because one of your affiliates did not keep records carefully for the 5 years as required under law, for example. And it's very difficult to do it post hoc, meaning after an audit is open, trying to scramble to get the documents necessary to submit to CBP when an audit survey is presented to you, for example. So these are some issues that we think you should proactively manage so that you can minimize some of the trade compliance risks, and also to be able to spot the red flags that allows you sufficient time to take proactive measures to minimize some of the risks that happen because of human errors. So prior disclosure is a very good example. You don't know of certain errors unless you have a regular audit of your company's compliance system. And you wouldn't have sufficient time to then gather the necessary information and ensure that you have a proper record retention policy in place, and that you have a policy to try to get some of the necessary documentations from other affiliates, other divisions that will be necessary to fully comply with any requests for information required for origin verification purposes, for example. Now, one last thing I do want to mention indirectly, we have had cases where companies are undergoing certain pending cases with the Korea Customs Service, and that would require us to get certain information from CBP. So letters, ruling requests. So those are tools available to help you indirectly in a case that is pending in Korea and not necessarily an open case opened by a CBP or other US agencies. So those are some cases that I wanted to highlight. I know that attendees most likely have a lot of questions for the panel. So I'd like to turn it back over to Katrina for the Q&A session. Thank you.
Thank you, Soo-young, for the practical advice. Now we have several questions. I know it's over, it's after 10:05. Mr. Leonard, can you take a couple of questions? I know his time is over.
I think we can have a few minutes of questions, sure.
Okay, so this question is about trade remedy. For China-produced parts, if, for example, automotive components, retaliatory tariff is 25% in addition to 2.5% regular duty. Is there any way to postpone or avoid 25% of the retaliatory tariff. With the Biden administration will change.
Ms. Chung, thank you so much for your question. So to address your question, so technically, no, there's no way to postpone or avoid the 25% retaliatory tariffs unless USTR grants an exclusion for those products. So the automotive components on the 6-digit, there has been, USTR has granted prior exclusions for the 6-digit tariffs. So I would just advise that the importer review the Federal Register notice to determine if the description of the goods are within that exclusion product description. So if USTR did grant an exclusion for those products, then they can definitely use the exclusion tariff as the 9903/88 tariff to be excluded from those duties.
Thank you.
You're welcome.
Maybe last question is on forced labor. For the goods exported by the Korean company, if a WRO is issued for suspicious of using forced labor, the US importer has to prove that there was no forced labor involved throughout the entire production process. What action could be taken by Korean exporters in such instances?
Well, I would say that, that there needs to be cooperation and transparency between the importer and, the Korean exporter. As you've mentioned, the American or the importer of record will need to show in order to trace the supply chain from the origin of the item to the production and processing of downstream products to the merchandise imported into the US. So it's important to maintain that positive relationship so that the importer will be able to obtain the documents necessary to show CBP that the entire supply chain was clean of forced labor.
Thank you. In the interest of time, for those questions we didn't get to, we'll try to get back to you with answers. Now, before we wrap up today, I would like to invite Mr. Leonard again for brief closing remarks.
Thank you, Katrina. I just wanted to say thank you for joining us this morning. We appreciate the opportunity to present this very wide portfolio that you heard. You got an awful lot of information, I think, in an hour, including the Kim and Chang presentation. And as Katrina mentioned, we are happy to follow up with the questions that we weren't able to answer. We can get those to you. But again, great to see everybody virtually, and we hope to see you in person soon in Seoul, Korea. Thank you so much, Katrina, and thank you, Mr. Kim.
Thank you so much. All the CBP presenters, you all have open invitation to Korea. So now we hope you learned and enjoyed this presentation, and this concludes the webinar. On behalf of AMCHAM Korea and my new co-chair for the Trade and Customs Committee, Ari, thank you all for attending and hope to see you in person next time.